sharing. So to introduce, to start off, I've attended a webinar organized by Sabah Law Society and the associates, the Advocate Associates of Sarawak, based on the similar topic titled Legal Practice, Litigation in the New Normal. So without further ado, I will introduce my overview of the sharing, mainly focusing on three areas. A, the existing normal, what has been usually done by the courts before MCO. And then B, the new normal, in light of the MCO, what initiative has been introduced to curb the difficulties raised. And C, the said initiative, which is this virtual hearing. I will share on its SOP, the requirements, and its etiquettes. Now, this is the existing normal before MCO. I will not share on the A to Z of the beginnings and the endings of a court case, but I will share on the legal conduct of courts in dealing with court cases. Everything okay? Okay. So in terms of the legal conducts of courts, among others will be case management or mention. This is to manage and to ensure the smooth progress of the case, to ensure that the case do not fall behind or that they are not long overdue. So for case management and or mention, usually physical attendance of the lawyers will be required in court, or e-review system can also be utilized, whereby lawyers do not need to be physically present in the court. They can conduct case management or mention online through this e-review system. Next will be hearing. Now, hearing, as the name suggests, it is to hear the submissions of the parties lah. And for hearing, it is quite diverse in depending on the nature and the complexity of the case. Hearing can be conducted requiring the physical presence of the lawyers in court or through e-review system. Now, if the hearing is straightforward, simple case, then it can be done so by e-review. However, if it is complex, if it is lengthy, then it will require the physical presence of lawyers in court. Next, I will explain on trial. Now, trial, it will involve a process of examining witnesses of each parties. So this process usually is complex. Usually it is at least it will take about 3 hours or more. So for now, there is no record of any trial conducted via online. So physical presence of lawyers is required in court. And then it will be decision. Decision is to deliver decision of the court to parties. So it can be conducted via physical presence of the lawyers in court or e-review. Now, in light of MCO, court premises have been closed during this time. However, the latest circular by the Bar Council number 137, if not mistaken, have since said that the courts are now partially open, meaning that the counters of registration of payments and etc. have been open since today, 4th of May onwards. But for the legal conducts of court, such as the case management, whatever I've just said just now, will only proceed from after expiry of the MCO, which is tentatively fixed on 12th of May. Now, because of the closure of court premises, there are some conducts that cannot proceed, but some conducts which can proceed during MCO. So this is some of the conducts that are stipulated in this Bar Council circular. All trials and hearings will be adjourned until further notice. Any case management for criminal cases in federal court and court of appeal will also be adjourned until further notice. But for criminal cases in lower courts, in respect of bail and remand applications, will proceed as usual. Now, this is because accused person, okay, arrested person, who are subjected to bail and remand applications concerned with their liberty. So if they are not, if they cannot proceed with their bail or remand applications, they will be continued to be locked up. So this will be unfair for them. And that's why it is just for the courts to proceed with the bail and remand applications even during MCO period. Then for case management in civil cases, scheduled to take place via e-review will proceed as usual via online. But for those that require physical presence of the court, manual case management will be adjourned until further notice. Now, the new normal, in lack of MCO, to ensure that cases can still move on even in this period, there's this Bar Council Circular 077/2020 that notify and informs fellow members of the bar that the court have since now allowed parties in civil cases to apply to courts for an online hearing. So as mentioned just now, trial and hearing are not allowed to are adjourned until further notice. But with this application, parties in civil cases can now apply for an online hearing. But there are some conditions stipulated. Now, online hearing can be done so in 3 forms, either by way of e-review or exchange of emails or through video conferencing, also known as virtual hearing. For uniformity, I will address it as virtual hearing from now onwards. Now, if it is to be done so by virtual hearing, it has to be applied 3 days by way of email 3 days before the hearing date or pursuant to any direction of the court. The conditions attached to the online hearing, there are 2 conditions. One is the consent of parties. The other one is the leave of court subject to the discretion of the court. Now, the court will take into account many factors when it comes to allowing online hearing. Among others is the prevalence of COVID-19 cases in district area which the court or the relevant parties are located, the difficulty faced by the relevant parties in traveling to court, the nature, expected length, complexity, and urgency of the hearing, and also any possible prejudice that may be caused to the parties if the hearing is adjourned. Now, in subsequent thereto, there is also restriction in terms of what kind of proceedings that can apply for online hearing. Pursuant to this circular number 077, in terms of high court and lower courts in Peninsular Malaysia, only hearings for ex parte and inter parte applications filed together with certificate of urgency can apply for an online hearing. In terms of the courts in Sabah and Sarawak, all proceedings including mentions, application, trials, appeal hearings, mediation, case management, clarifications, and decision, which dates have already been fixed, will take place via e-review or video conferencing. Now, this circular has extended the proceedings applicable for online hearing, but these proceedings are only subject to those in High Court of Malaya, which extended to applications of parties in respect of interlocutory appeal trials, interlocutory applications that are not contested, and if those contested which are short and straightforward, and also appeals to judge in chambers against decision of deputy registrar and also assistant registrar, decision of the trial, and also any mediation proceeding. Now, as mentioned herein, online hearing can be conducted via e-review, exchange of emails, or video conferencing, i.e. virtual hearing. Virtual hearing here is the latest initiative introduced by the courts in light of MCO. So virtual hearing here is the, it can be said in a sense, the new normal introduced by the courts. So this circular, Bar Council Circular number 124 here has introduced its SOP. In terms of preparation for virtual hearing, main tasks will actually fall on the court registrar or interpreter. They will have to obtain the consent of the parties. They have to get their contact number details and email addresses in order to prepare the session. They have to issue a notice of virtual hearings at least 3 days before the hearing. And then for parties' part, they will have to ensure all the documents are e-filed, because only those e-filed can be referred. They have to download the relevant software that will be utilized for the virtual hearing. Now, in terms of the SOP, they have referred to Skype for Business or Skype, and then expressly also stated that Zoom application is not allowed. So in terms of the software part, the parties will have to ensure the usernames reflect the actual party's name for easy reference of the court, and then also it is advisable for them to log into the software to familiarize with the setting of the software. If the client wishes to join the session, the party has to make an early application to the court to apply so. And then virtual hearing can be conducted from offices and houses of the judge and parties respectively. In terms of conducting the virtual hearing, first, also the court registrar and interpreter, they will send a reminder email, or they will contact the parties 30 minutes before the hearing. They will send an invitation of the video conferencing software to the parties to join the virtual hearing session. Again, it is stated here that examples of this software can be Skype or for business or Skype. Zoom application is not allowed. And then before the actual virtual hearing starts, there will be a short trial run to ensure the audio, the video qualities are up to par. And then each session will have to be recorded using the built-in recorder of the software. Based on the recording, the notes of proceedings will be prepared and then subsequently recorded into the court system. So at all times, the parties will have to ensure the courtroom etiquettes are followed, even though this is not a formal courtroom setting, but it is still a court proceeding. So the etiquettes referred to, among others, will be to dress in appropriate court attire in chambers, to use the appropriate virtual background, if any, and any kind of voice modulation is not allowed, to ensure that only those invited are present in the virtual hearing, no outsiders is allowed, ensure that the body and face of the party is positioned facing towards the camera so as to be visible and identifiable by the judge. Do not make any unmannered hand gesture or body language, body movement. Do not eat or drink during the session, although occasional sips of water in a manner that does not distract or disrupt the session may be allowed. And also be present at all times in the session. Do not leave without the judge's permission. Now, in terms of requirements of virtual hearings are more technical in nature. There are requirements in terms of hardware requirements and internet access, the speed and all that, so I will not bore them with you. Then is the etiquettes part. Etiquettes part, first of all, is each virtual hearing setting has to be sufficiently lit without noise disruption. Ensure that the device used during the hearing has sufficient battery, and also to ensure that the internet line and access are sufficient to avoid any disconnection. Ensure that the web camera and microphone of the device are in order. And if there's any disruption, okay, to the video screening or the audio or the internet, which sometimes is unavoidable, must inform the judge immediately. So for that, the judge may delay the virtual hearing session for a while, or if the disruption cannot be overcome with, then the court might fix another date for the hearing. Now, in conclusion of my sharing is this latest initiative introduced by the court, i.e. the virtual hearing by way of video conferencing, is a step forward in digitalizing the conducts of the court. One of the key speakers for the webinars that I've attended is Tan Sri Datuk Wong Dakwa, who is a retired Chief Judge of High Court of Sabah and Sarawak, has said that it is very important for lawyers nowadays to embrace technology in order to enhance our own efficiency. So as I've mentioned, he is a retired Chief Judge, as you can imagine how old he is. So age is really no excuse for every lawyer to be well equipped of familiarizing ourselves with the knowledge of technology and the digital world. So that's so much for joining my session. I believe there will be no questions from the floor. So that's it. Thank you so much.